Number 209, the people of the state of New York versus Cristian Morales.
Good afternoon, Your Honors. Dory Cohn for Appellant Cristian Morales. I would like to reserve 2 minutes for rebuttal.
2 minutes, Ms. Cohn?
Yes, please. Thank you. The rule this court stated in Ventura and Harrison is clear and applies directly to Mr. Morales' situation. Deported defendants have an absolute right to intermediate appellate review of their convictions, regardless of the issues raised on the appeal or the basis of the deportation, in situations where it's a direct appeal as of right.
Could the appellate term have dismissed based upon the failure to timely perfect or abandonment of the appeal?
Well, they could have issued an order to show cause as to why the appeal should not be dismissed, and we would have had a chance to respond stating that we fully intended to do the appeal.
Is that the process that's used whenever that's done in that particular court?
Yes, but in fact, that particular court, they keep track of their cases. They send out status letters. And in this case, it occurred. We responded to every status letter they sent, and during the course of our communications with the term, we told them that that Mr. Morales had been deported, that pursuant to People v. Ventura, we had to perfect the appeal, and we intended to perfect the appeal. But we were going to be giving it a lower priority to do the appeals of other defendants where a result
I
would...
assume that the people didn't move to dismiss on that ground.
No, they did not. They only moved to dismiss after the appeal had already been perfected. And we wanted to do the appeals of defendants where a result would have a more immediate impact. We fully intended to always perfect this appeal. And in fact, it couldn't be perfected right away, as respondent states, because first of all, we didn't get assigned till 1 month after he was deported.
What's the downside of it being dismissed without prejudice, so that if he comes back, you know, he can always argue his appeal?
Well, the downside is that, first of all, the transcribed minutes might be harder to obtain because you might not be able to communicate with the court reporter. In addition, the people's witnesses might become unavailable. So there's several downsides, and in fact, this court considered that. That could have been a reason for the Ventura and Harrison decisions. And this court had already decided that these deported defendants would have a right to review, because prior to Ventura, it used to be that these appeals would get dismissed without prejudice to be reinstated should the appellant return to the jurisdiction of the court. So
And part of that was that you can't get back to the, sometimes you can't get back to the jurisdiction of the court because as a result of your conviction, you've been deported, right?
yes, yes. But as this court stated in Harrison, that's for the lower court, that issue of what happens with the appeal is for the lower court to deal with, because I believe you asked the question, Judge Piggott, that if there's a mistake, shouldn't we correct the mistake right now? You asked that in the Harrison oral argument.
Counsel,
So-
what's the role of appellate counsel vis-a-vis the relationship with the client in the appellate process, the interaction? And is it your position that you did not need to interact?
Well,
client?
it's our position that, first of all, we did interact. He communicated his desire to appeal. So we filed a notice of appeal 1 week after his conviction. He was immediately remanded into ICE custody because he had fully served his sentence already on the date of conviction. We then sent him a financial affidavit and explained to him that he needed to fill it out and return it to us in order to get counsel assigned to the appeal. And he did that, thanking us for taking care of his appeal, and when he got deported, he fully knew that his appeal was going to be taken care of. We didn't get assigned till...
On the substantive issues?
I'm sorry?
On the substantive issues associated with the appeal?
Yes, because it was a direct appeal as of right. It was a full jury trial. It was completely record-based. There was no possibility of additional jail time exposure like there would be in, say, a guilty plea, for example. And it wasn't a permissive appeal. It didn't have any of the issues that the cases cited by respondent, you know, those issues were not a factor in
That's
this.
your appeal. What about the next one? You know, with all of these, you know, you indicate all of these things that are not part of yours. If they're part of the next one, isn't it always the same, that we're not going to dismiss these cases?
Well, I think in the case of a guilty plea where there would be the possibility of additional jail time exposure, there would be additional issues associated with that, which is not the case here. But in the case here, it was completely record-based. A comprehensive brief was filed in this matter. The appellate term never made an order to show cause to dismiss the appeal, and the people never moved to dismiss it based on lack of perfection.
How do you handle, this is someone who is supposedly unavailable because of the deportation. Well, how do you handle other people who might be transient? I think you may have raised in your briefs the question of someone who's homeless. What potential spillover effect does a decision in this case have?
Well, first of all, we always reach out to all of our clients and invite them to communicate with us. And we can't force that communication for one reason or another. Some of them can't or simply choose not to communicate with us. That should not mean that they lose their rights to intermediate appellate review of their convictions. They're still entitled to have that considered review. So if it's record-based and there's no possibility of additional jail time exposure, we do the appeal. We perfect the appeal and write the brief and file the brief.
So your
But-
position, if they've gone forward with the notice of appeal,
Notice of appeal and the order of assignment.
and the order of assignment, that's an indication that they wish to proceed, and
Yes,
that they're not abandoning the appeal in any shape or form.
that's correct, Your Honor. And that occurred in this case. That was enough for us to go ahead and do the appeal. And we communicated with the appellate term. They knew about the case, and they knew they didn't lose track of it in any way, and they accepted the brief when it was filed.
Do we need to know if the appellant is still alive?
Well,
Does that affect anything here? Would it if he wasn't?
well, first of all, if he wasn't alive, he would win the appeal.
That's true.
Stone winner.
So in that case, you
Not
know,
incentivized, though.
a job would be successful. But
Not.
I suppose, but if typically, let's say he wasn't deported and he was here and he was one of those transient people, if our letters were not returned to us, we would expect that they got received, and we wouldn't, and for one reason or another, they weren't communicating with us, and we would still be able to do our jobs. They would still be able to have their statutory right to appeal.
Thank you, counsel.
Thank you.
Counsel?
May it please the Court, I'm Adam Charnoff, representing the Office of the District Attorney of Nassau County. Your Honors, the appellate term providently exercised its discretion when it dismissed the appeal of a defendant who had been missing for 3.5 years following his deportation and vanishing in Honduras.
How do you distinguish Harrison and Ventura, or the opposite way, Ventura and Harrison?
Your Honor, just because this case involves a deported defendant doesn't mean that the validity of the dismissal isn't as great as it would be applied to a resident of this country. It was dismissed, among other reasons, for lack of communication between the defendant.
So you're saying it would have to be the sole reason for dismissal, that the person was deported?
If the person was deported.
Well,
But
but
the appellate term made it very clear that there were several reasons
Well,
for
but the appellate term made it without prejudice to right to renew if he returns to the jurisdiction. It didn't make it without prejudice to leave to renew if he contacted his attorneys. So doesn't that indicate that it was in fact his deportation that was the basis of the
Possibly
dismissal?
prior to this court's holdings in Harrison and in Ventura, that might have been the reasoning of the appellate term. However, now, post-Harrison, post-Ventura, this court could nevertheless affirm the order of dismissal and then direct this defendant to file a motion to reinstate his appeal in light of the new holdings in Ventura and Serrano.
Why would that be necessary now, counsel? Because apparently he's in contact with his lawyers and they have the
His
authority to go forward.
existence has finally been confirmed, and his whereabouts is confirmed. What still has not been resolved is whether this defendant, during this 3.5-year total disappearance, blackout, no communication, no responding to defense counsel, whether that abandonment is sufficiently overcome by defendant's belated and superficial expression of interest
Well,
of
why is it
continuing.
an abandonment? He got the notice of appeal, get the assignment of counsel, there's no he thanks them for their involvement. Is it your position he's got to constantly contact them? Every
No,
week he's
but-
got to check in and say, I still want to move forward with this appeal?
No, Your Honor. What I do say is that there is a lot of information missing from this case. We don't know what efforts my opposing counsel did make to contact this defendant, nor does she say. She does
Well,
not.
What I'm saying is, why would she have to say that? She's got
Because
a client who said, move forward with the appeal, and they're moving forward with the appeal. Why does she have to say that? And at what point in time?
Because-
Under your rule, is sort of the client who is not checking in regularly or is just receiving mail and doesn't respond to it, now the person who has abandoned?
Well, especially somebody who is in another country, who is receiving communications from his attorney, and I assume that his attorney was trying to communicate with him. At some point, there is a responsibility for a defendant to at least respond in a minimal way. I mean, it's
But
this.
isn't
To
that
say
when
what,
the-
I'm got your letter, thanks. Is that what you mean? Because let's say there's nothing in the letter that triggers any concern on the part of the client.
Well,
They're still satisfied with the representation they are up to that point receiving.
Well, there
You're
is
saying
a-
they've still got a contact?
there is a responsibility to at least respond at some point. I got your letter.
Doesn't that ignore
I-
this particular situation where
Yes.
someone is deported, where it may be extremely difficult to communicate, and yet that person beforehand has
But
has
clearly
made
in-
it clear that they want to move forward with the appeal?
But clearly, in this case, there was ability to communicate. I mean, in opposing counsel's brief to this court, they are in regular contact via email, via text.
So what's the downside? I mean, why don't you just let the appeal go forward? It's a DWI, it's not a killer
The
case.
downside is that this court should not create a misimpression that the intermediate appellate courts have absolutely no discretion to control their
Well, but
overburdened
here, the
dockets.
appellate term could have served an order to show cause, or sent an order to show cause, as it's my understanding that's the way they do it, why it shouldn't be dismissed based upon abandonment.
Well, it was only
do that,
due to
right?
my motion to dismiss
Or you,
that
and you didn't
became.
move to dismiss on that ground either, did you?
I did,
You did, on abandonment.
among other reasons. So it was abandonment, also irregularity of preparing a brief without any communication with or input from a client. And also just it was just not clear whether this defendant was alive or dead. What was his existence? And in that particular situation, even intermediate appellate courts should be allowed to control their dockets to remove those appeals of defendants absent
But not,
a
but not if
showing
it's-
that the defendant existed.
But not if it's just based on something other than that, if it's based on the fact that he was deported.
Exactly. And this case would also afford the court an opportunity to perhaps come up with some guidelines
Isn't this
for-
the attendant circumstances of deportation, the difficulty to have ongoing communication with counsel? I mean, if counsel came back on, just take out, counsel comes back on the motion, says, yes, the last time I spoke to the client, the last time there was communication with the client made very clear we're moving ahead with this appeal. Would that be enough, even if there's no communication for another 2 years?
2 years or 3.5 years, it should be incumbent on counsel to first ascertain whether the defendant still existed and where he existed before undertaking the preparation of a very lengthy.
That kind of presumption applies in this involuntary deportation context.
Yes.
Mr. Chernoff, I'm curious, are we talking big numbers here? In other words, it struck me that, let's assume there's, I don't know, let's make it 50 of these appeals pending. They're all dismissed without prejudice. This one comes back.
Correct.
The other 49 are sitting there somewhere. Why not just hear it? The other 49 will probably lay there for the next 10 years.
Because those are 49 or 50 cases to which there should not be an allocation of scarce appellate judicial
There aren't. They're
resources.
just sitting over on a shelf. They've been dismissed without prejudice.
Right. Oh, I'm sorry then, I
I'm
misunderstood the
saying, you
question.
just leave them out there. But if somebody comes in and says, guess what? We found our client and,
They can do a motion to reinstate the appeal.
okay.
And what would be the standard to grant the motion? Is there a burden, or is it going to be pro forma?
The burden would be the alleging of facts in affidavits from the defendant, affirmations from appellate counsel, asserting certain facts which demonstrated that the defendant did not abandon his appeal, that defendant, in fact, may have been unaware of counsel's actions in trying to communicate with him, any number of things, but there have to be allegations of additional facts that would support an appellate term's decision.
When I
to
left, I
reinstate.
told them I wanted to move forward. I filled out all the forms. They did a notice of appeal. I got deported. I got thrown in jail for 3 years.
Right.
There was no way to communicate with me. I always understood that they were going to move forward with the appeal. I assume that's an example where
That's
you'd
an
say
example.
that works.
Correct.
Okay, so why can't they move forward with the appeal while the deportee is in some jail in another country? Why not?
Because he's simply in another jail?
Yes.
Well, that's different from this particular
And if they
case.
were in the United States, she could continue, right?
Correct.
Right.
But there
And would
is-
you complain if, would you be saying, well, she's got to communicate with her client regularly?
No. What I'm saying is there has to be at least minimal communication, even one conversation, whether it be orally, in letter,
At what
in
point?
email.
At what point, how often?
Once every 3.5 years. How's that? I think it's quite reasonable for an intermediate appellate court to at least have some reassurance that this defendant, after such a long period of time had elapsed, is alive, exists, and is interested in
People
proceeding.
don't get declared to be dead unless they're missing for about 7 years, right, counsel? Usually that's what happens.
Right, but the point is, does the appellate term have to be required to still, determine the merits of this possibly deceased defendant?
But I don't understand why you're so concerned about that. I mean, they're the ones that are be concerned about that their client's dead or alive or all of this stuff. And they filed a brief, and your point is that they should have filed a motion.
Correct.
Instead of filing the brief. Then you moved to dismiss, but the brief's there. You could have filed another one. We'd have been done with this case about 2.5 years.
That is true, but this affords the court the opportunity to
get the-
provide some guidance in the future.
We appreciate that
Thank you,
very much.
counsel.
Thank you very much.
Ms. Cohen, what about your colleague's argument about the application of scarce judicial resources? How does that fit in for us?
Well, Your Honor, first of all, there was no abandonment of this appeal. We got assigned to appeal. There was nothing defective or irregular about this. We perfected the appeal, and then after that, the appellate term dismissed it, partially based on his deportation, and cited Ventura. So contrary to what Respondent just stated, Ventura had already been decided prior to the dismissal of this appeal. We were without authority to not go ahead with the appeal because of the order of assignment. We never heard anything from the defendant that stated, don't go ahead with my appeal. The last instructions he gave us were to do the appeal. So we were complying with the order of assignment. There's never been a rule regarding communication between appellate counsel and their
I
clients.
didn't notice it, but why did it take 3.5 years? And if you're going ahead with the appeal, why wouldn't it have happened within 9 months of the time of the sentence?
Well, first of all, it took 9 months to get the transcript in this proceeding and to settle the record. So for the first 9 months after he was deported, no one could physically work on the appeal. These things take time, apparently. But then for the remaining 2 years or whatever it is, we gave it a lower priority to work on the appeals of other clients in which there would be a more immediate impact, and we notified the appellate term that we were doing that.
So some of the scarce resources are your own that we're talking about, right?
That's true, but this court issued Ventura, and we tried to comply with it. And we believe that Mr. Morales fell squarely within that framework, and the rule was that we had to do his appeal. We got assigned to it. The ruling in Ventura came down 1 year earlier, so we felt that we felt an obligation to perfect his appeal.
Should it have been reassigned then to counsel that didn't have the kinds of perhaps financial challenges and demands, volume demands that your office has? So that we wouldn't be waiting this, or the client and the court wouldn't be waiting these 2 or 3 years?
Well, the court found him to be indigent, Your Honor, so he's always going to get assigned counsel, and
So it would be the same,
It would
you're saying
be an
it'd be the same
institutional defense.
situation regardless?
yes.
Counsel, I'm having some trouble understanding how Judge Piggott's question about your scarce resources would affect this analysis.
Well, I think that's just a fundamental misunderstanding by Judge Garcia of my question in the first place.
I'm thinking I can't wait to get your appeals up here in the future. We're joking.
Inside baseball.
Thank you,
Really
counsel.
concluded again, those two.